Hello everyone, how are you? This is our first lesson under Administrative Law and the Law on Public Officers. In this lesson, we will only be discussing the preliminaries and the background of the existence of administrative law. Before we go to the law on public officers, let us first define what is administrative law. And when we define administrative law, we will also be tackling its general principles. So what is administrative law? It is a branch of public law fixing the organization and determines the competence of administrative authorities and indicates the individual remedies for the violation of the rights. If we are to dissect the definition of administrative law, we always look into public law, fixing organization, determining competence, and individual remedies. So class, always remember that administrative law is a branch of public law, meaning it is a subset of public law which deals with the relationships between individuals and government entities. It focuses specifically on the actions, powers, and duties of administrative agencies. So in the Philippines, administrative law governs the activities of various government agencies, departments, and instrumentalities to ensure that they operate within the bounds of the law and adhere to the principles of fairness, accountability, and transparency. And when you look at the definition, there is also the word fixing the organization. It is a branch of public law fixing the organization. Why is that? Because administrative law establishes the structure and organization of administrative authorities, and this includes defining their power, functions, and jurisdiction. So in our country, administrative law dictates the creation and organization of administrative bodies such as Civil Service Commission, Commission on Audit, and the Office of the Ombudsman. It outlines their mandates, powers, and limitation. Now, if you look into the definition of administrative law, there is also the word determines the competence. When we say determining competence, administrative law class determines the authority and competence of administrative bodies to perform specific functions. It delineates the scope of their jurisdiction and the extent of their powers. In the Philippines class, administrative law sets forth the competence of various administrative agencies to regulate specific sectors or address particular issues. So for instance, the Security and Exchange Commission regulates securities and investments, while the Department of Environment and Natural Resources oversees environmental protection and conservation. So you see, we have different government agencies, and these government agencies' competence are defined through their powers, limitations, and jurisdiction. The definition class also set forth individual remedies. Hence, administrative law provides remedies for individuals whose rights have been violated by administrative actions. These remedies may include judicial review, administrative appeals, or other forms of redress. So when it comes to administrative law, individuals can seek recourse through mechanisms such as filing administrative complaints in different government agencies, petitioning for certiorari before the courts, or resorting to alternative dispute resolution methods like mediation or arbitration. So administrative law ensures that individuals have avenues to challenge unlawful administrative decisions and seek appropriate remedies before going to the court. All in all class, administrative law in the Philippines plays a very important role in regulating the actions of our different government agencies. It safeguards individual rights and promotes good governance. Aside from that, administrative law also provides legal framework within which our administrative authorities operates and ensures accountability and fairness in their actions. So what are the different kinds of administrative law in the Philippines? We have statutes setting up administrative authorities, body of doctrines and decisions dealing with creation, operation, and effects of determinations and regulations of such administrative authorities. We also have rules, regulations, or orders of such administrative authorities in pursuance of the purposes for which administrative authorities were created or endowed, and determinations, decisions, and orders of such administrative authorities in the settlement of controversies arising in their particular field. Let us discuss these kinds of administrative law one by one. So again, what's the first one? The first kind of administrative law are statutes setting up administrative authorities. So an example of this is our Security and Exchange Commission. So the existence of Security and Exchange Commission is due to what law? RA number 8799 or the Securities Regulation Code. These statutes set up the SEC as the primary regulatory agency overseeing the country's securities market and ensures compliance with securities laws. Another kind of administrative law are those body of doctrines and decisions dealing with creation, operation, and effect of determinations and regulations of such administrative authorities. So these kind of administrative law class encompasses the legal principles, doctrines, and judicial decisions that govern the establishment, functioning, and impact of administrative agencies, determinations, and regulations. So for example, when we say doctrines and decisions, our Supreme Court, of course, has issued numerous decisions interpreting the powers and limitations of administrative agencies. Another kind of administrative law are rules and regulations or orders of such administrative authorities in pursuance of the purposes for which administrative authorities were created or endowed. So this refers to rules and regulations by administrative agencies to implement, class, and enforce the laws within their respective areas of jurisdiction. So for example, our BSP or the Bangko Sentral ng Pilipinas issues rules and regulations to supervise and regulate the operations of banks and financial institutions in accordance, of course, with RA number 7653 or the new Central Bank Act. So these regulations formulated by the Bangko Sentral ng Pilipinas covers various aspects of banking operations only, such as capital requirements, lending practices, and consumer protection measures. Another kind and the last kind of administrative law are those determinations, decisions, and orders of such administrative authorities in the settlement of controversies arising their particular field. So if a while ago we discussed decisions and doctrines of the Supreme Court, this last kind of administrative law pertains to the administrative agency's resolutions, decisions, and orders in resolving disputes or controversies that fall only within their specialized domain. So here in the Philippines, our National Labor Relations Commission or the NLRC adjudicates labor disputes and issues determinations on matters such as, unfair labor practices, illegal dismissal, and collective bargaining disputes. So its decisions serve as final adjudication within its jurisdiction, but this is of course subject to judicial review in certain cases. So those are the different kinds of administrative law which illustrate the multifaceted role of administrative agencies in implementing their own laws, in resolving disputes, and in regulating various sectors of the society in the Philippines. Now let us go to the creation of administrative bodies and agencies. But before that, what is an administrative agency, class? So an administrative agency is an organ of government other than a court and the legislature which affects the rights of private parties either through adjudication or rule making. And how are these agencies created? Number one, by constitutional provision, by authority of law, and by legislative enactment. So ano po ang pinagmulan ng ating government agencies? The first one is through constitutional provision. When we say constitutional provision, class, some administrative agencies may be created directly by the Constitution of our country or our 1987 Constitution. So constitutional provisions outline the structure, powers, and functions of these agencies, often in relation to specific areas of governance or sectors of society. So an example of this one is our Civil Service Commission, the Commission on Election, and the Commission on Audit, which is particularly provided for in Article 9, Section 1 of the 1987 Constitution. Kindly double check ha. But these are actually agencies created through constitutional provisions. Another one is through the authority of law. In some cases, class, the authority to create administrative agencies may be delegated to the executive branch or other governmental bodies through existing legal frameworks. And these laws provide the legal basis for the establishment of administrative agencies and define their scope of authority. Lastly, we have legislative enactment. So, administrative agencies, class, can also be created through legislation passed by the legislative branch of the government. These legislative enactments explicitly establish the administrative agency, define its purpose, delineate its powers and responsibilities, and provide funding for its operations. So in our country, usually, class, administrative agencies are typically created through legislative enactments, which may be in the form of statutes, executive orders, or presidential decrees. And these laws specify the mandate, structure, and functions of the administrative agency, as well as the procedures for appointment or selection of its members or officials. So what then are the reasons for the creation of administrative agencies? Pwede namang wala, di ba? But why do they exist? First is to help unclog court dockets. Second is to meet the growing complexities of modern society. Third is to help in the regulation of ramified activities of a developing country. And lastly, to entrust to specialized agencies the task of dealing with problems as they have the experience, expertise, and the power to dispatch to provide solution thereto. So why do administrative agencies help unclog court dockets? These administrative agencies, class, are often tasked with handling disputes and issues that, if brought directly to the courts, would overwhelm the judicial system kasi marami na tayong cases in court. By delegating certain functions to administrative agencies, governments can relieve pressure on the courts, allowing them to focus on cases that require judicial intervention. Administrative agencies, class, can efficiently handle matters such as licensing, permits, and regulatory compliance, reducing the burden on the judiciary and promoting quicker solutions of dispute. Second, to meet the growing complexities of modern society. So with our administrative agencies' diverse economic, social, and technological dynamics, it requires specialized knowledge and expertise to regulate different rules effectively. So our administrative agencies are created to address these complexities by developing and implementing regulations and policies, which are actually in a form of programs tailored to specific industries, sectors, or societal challenges within their jurisdiction. So these agencies, class, can conduct research, gather data, and collaborate with the stakeholders to formulate regulations that adapt to evolving circumstances and address emerging issues in the country. Third, to help in the regulation of ramified activities of a developing country. So our country, class, actually faces different challenges related to economic development. Meron din po tayong infrastructure problems, public health, now dito sa Davao Oriental, environmental protection problems, and social welfare. So administrative agencies play a crucial role in regulating and managing these complex and interconnected activities. By overseeing sectors such as agriculture, energy, meron din tayong transportation, healthcare, and education, ang ating pong administrative agencies contribute to the orderly development and sustainable growth of the country because our government agencies are expected to establish standards, mag-enforce ng regulation, and gumawa po ng programs to promote economic progress and of course, protect the welfare of the Filipinos. Lastly, one of the reasons why administrative agencies are created is to entrust to specialized agencies the task of dealing with problems as they have experience, expertise, and power to dispatch to provide solution thereto. Of course, when it comes to environmental problems, you have to consult the Department of Environment and Natural Resources because there are certain issues that require specialized knowledge. So administrative agencies are created, class, to leverage their expertise and experience in specific field or industries to tackle complex problem and of course, to deliver efficient solutions. These agencies often have dedicated staff, technical resources, and regulatory authority to enforce laws, conduct inspections most especially, and implement programs within their areas of specialization. So class, always remember that the creation of administrative agencies serves multiple purposes, including alleviating pressure on the courts, addressing the complexities of modern society, regulating diverse activities, and leveraging specialized expertise. That is why the Philippines have different government agencies so that we can become a more effective and progressive nation. So sana naman our government agencies are functioning well. Since we have discussed what is an agency, what then is an instrumentality? Diba? Kadalasan, we always hear the instrumentality of the government. So what is an instrumentality? An instrumentality class refers to any agency of the national government not integrated within the departmental framework, vested with special function or jurisdiction by law, with some, if not all, corporate powers, administering special funds, and enjoying operational autonomy, usually through a charter. So how will you say that that is an instrumentality of the government? Number one is that it is not integrated within the departmental framework. So unlike government departments, which are actually part of the executive branch's organizational structure, instrumentalities operate separately from the departmental hierarchies. They are vested with special functions or jurisdiction by law. So instrumentalities are established by legislation to fulfill particular purposes or carry out specific tasks assigned to them by law. Next is that our instrumentalities possess corporate powers, meaning they have or they may have the authority to enter into contracts, sue and be sued, acquire and dispose of properties, and undertake other actions typically associated with corporate entities. Another one is that instrumentalities administer special funds, meaning they often manage funds earmarked for specific purposes such as infrastructure development, social welfare programs, or industry promotion. Our instrumentalities also have operational autonomy, meaning they enjoy a degree of independence in managing their affairs, including their budgeting. They have fiscal autonomy, staffing, and decision making. But they must always be related to Philippine laws. Various instrumentalities exist to carry out specialized function and address special needs within the government. So for example, class, di ba meron na tayong AFP, there are uniformed personnel, but we also have the PNP. We have the Civil Service Commission, but why do we have the DILG? So these are just some examples of instrumentalities of the government. So the Philippine National Police is an instrumentality tasked with maintaining peace and order, enforcing laws, and preventing crime. It operates independently of the Department of Interior and Local Government and has its own charter under RA number 6975 as amended by RA number 8551. So before kasi PNP is really under the DILG, but now because of RA number 6975 which established the Philippine National Police under a reorganized Department of the Interior and Local Government. Then meron na namang RA 8551 or an act providing for the reform and reorganization of the Philippine National Police and for other purposes amending certain provisions of RA number 6975. Another example also is the Philippine Health Insurance Corporation or the PhilHealth, which is another instrumentality responsible for implementing the National Health Insurance Program. So it is created by RA number 7875 as amended by RA number 10606 and has corporate powers to administer health insurance funds and provide coverage to eligible individuals. So what then is the difference between an agency and an instrumentality of the government? There is actually no practical distinction between an instrumentality and agency for all intents and purposes. A distinction, however, may be made with respect to those entities possessing a separate charter created by a statute. But as to nature and function, class, when we say instrumentality, it is an agency of the national government that is not integrated within a departmental framework, while an agency encompasses a broad range of government entities including department, bureaus, offices, commissions, and authorities. As to operational autonomy naman, instrumentality enjoys operational autonomy as indicated in its definition. While an agency class may have an operational autonomy, it is not a defining characteristic of an agency in general. As to corporate powers, instrumentality may have some or all of the corporate powers, allowing them to function with a degree of independence akin to a corporation, while an agency may or may not have corporate powers. However, class, when it comes to regulation of private rights, ang instrumentality po primarily involved in the administration of special funds and operational autonomy does not necessarily engage in regulating private rights. But when it comes to agencies, they usually involve regulation of private rights, privileges, occupations, or business in its characteristics or nature. So here, agencies are often empowered to issue licenses, make rules, and adjudicate cases that affect private rights. So that ends our lesson number 1. In lesson number 2, we will be discussing quasi-judicial bodies and agencies. Thank you and have a great day ahead.